What's up, everybody? Welcome back to the channel. It's great to be here as always. Thank you for tuning in. I intended to cut this video like first thing this morning, but I had a whole bunch of errands that got stacked up in front. You guys know how that all works. So we're getting to the office a little late this morning, but we have some news out of the forced reset trigger case. So if you haven't been paying attention, this is a National Association of Gun Rights case out of the Northern District of Texas. And basically, the ATF got kicked in the teeth. And then after they got kicked in the teeth, they were like, oh, it hurt really bad. Judge, will you please give us a stay so that we could not have to do this thing? Because this thing is hard. And we've been waiting to see whether Judge Reed O'Connor was going to issue a stay or not. And I predicted that he would not. And that's what we're going to be talking about today. What did the judge say, and what does it mean for forced reset triggers? Today's video is brought to you by SlingSteady. SlingSteady is a system that was designed to create a more stable, easy to use, reliable squeeze bag than anything else on the market. It is a lightweight squeeze bag that attaches directly to your sling for recreational shooters, hunting, and long-range shots. With this, you're able to steady your rifle quicker and more effectively than ever before, and it attaches in just a couple seconds. This is an American-made product, and you can find all that information over on our affiliates page. Special thanks to SlingSteady for making today's video possible. I have a full video out that you can reference if you want to know what Reed O'Connor said in his initial decision, but I'll have it linked in all the relevant places for you guys to run down. But to really quick paraphrase what he said in his initial decision so everybody's on the same page. One, ATF, you are wrong. FRTs are not machine guns. They are not machine guns because they do not meet the statutory definition, and that is further supported by the Cargill decision that they do not meet the statutory definition, and you violated the Administrative Procedures Act when you tried to do this. So for those reasons, we are throwing out your rule. It is vacated, it's out of here, and you can't enforce it nationwide. Unless, of course, the ATF were to go fish for a sympathetic court somewhere and they were to rule to the contrary. And then you'd create a protected class, non-protected class, and that's you going straight to the Supreme Court. Probably won't do that, but who knows what they'll do. On top of throwing your rule out, we've also issued injunctive relief to the plaintiffs, and that includes NAGR, and that's also as an organizational plaintiff underneath of NAGR, or a commercial client under NAGR. All of the downstream customers of NAGR are covered. And that injunctive relief looks like this. You will return all of the FRTs that you stole. You will mail notices to everyone that you stole them from and anybody that you suspected of having them and being in violation of your rule. And you will do this within 30 days. The ATF comes back and says, hey, that's pretty heavy. What did Reed O'Connor say about it being too heavy? The ATF also tried to say that Cargill implicates the pull of the trigger, and that's exactly the opposite of what Cargill says. So let's pick up with Reed O'Connor. There are no new arguments or authorities in the Supreme Court's decision in Cargill. That's the whole thing about the trigger pull versus the function of the trigger thing. Accordingly, the court finds that defendants who bear the burden to show stay pending appeal is warranted fail to meet their burden here, let alone produce the strong showing required for such extraordinary relief as to stay pending appeal. Therefore, this factor weighs heavily against granting a stay. Regarding the second factor, which is irreparable harm, the court concludes that defendants have not shown that they will suffer irreparable harm. As before, defendants' sky is falling arguments do not overcome the serious harms plaintiffs face. Defendants' arguments are premised entirely on a presumption that FRTs are machine guns, a conclusion rejected by the court on 3 separate occasions. Defendants continue to offer speculative, conclusory statements about the supposed dangers of FRTs that are not supported by their own facts. Unlike earlier relief awarded to the plaintiffs, the court's final judgment ordered the ATF to comply with two affirmative obligations. One, return to all parties, including manufacturers, distributors, resellers, and individuals, all FRT and FRT components confiscated or seized pursuant to their unlawful classification within 30 days of this decision. Two, to mail remedial notices correcting their prior mailing campaign that warned suspected FRT owners that possession of FRTs and FRT components was purportedly illegal. Nonetheless, defendants have identified a number of practical considerations as it relates to the timeline to comply with these affirmative obligations. First, the ATF does not know the identities of organizational plaintiff claim members, let alone which of those members is entitled to return of their FRT devices. Additionally, plaintiffs are also unaware of some members who are eligible to return their FRTs. Defendants also contend that returning all FRTs covered by this order within 30 days is not feasible. According to the Cucks, they would have to go locate these devices among approximately 11,884 FRT-15s and WOTs in their possession, which may be held at different locations around the country. They would also have to determine whether owners are otherwise prohibited persons who cannot legally own a firearm before having to contact the owners and arrange for a return. The ATF claims that it is not able to comply with the court's order within 30 days. Pursuant to the inherent power of federal courts to control proceedings, the court determines that an extension, not a stay, is the appropriate relief here. Such extensions in this case are a reasonable response to the problems and needs. Thus, with a view toward the fair administration of justice in this case, and to effectively vindicate the full rights of the parties who succeeded on the merits, the court adjusts the compliance deadline. The practical issues of complying with the court's final judgment is sufficient reason for the court, in an exercise of its inherent powers, to modify deadline of the return of the FRTs in the final judgment, except as it applies to individual plaintiffs or members of the organizational plaintiffs who specifically request return of their FRT devices and provide sufficient documentation to the ATF. The court grants defendants an additional 6 months to comply with the affirmative obligations, which shall be completed by February 22nd, 2025. This extension does not apply to the individual plaintiffs or members of organizational plaintiffs who specifically request return of their FRT devices and provide sufficient documentation to the ATF. ATF shall return those as soon as practicable following this specific request. So ordered, Judge Reed O'Connor, 20th day of August, 2024. To translate that from lawyer speak, although I think Reed O'Connor does a really good job of writing in a way that most people can understand, no. However, you're sort of right about the fact that you stole these from people around the country, and all of these individual items are scattered across the United States, all 11,800 in some of them, so almost 12,000 of these things that you have to individually go and look for. All right, cool story. That makes sense. I'm not going to stay my decision, but I give you an extension for 6 months. So you got 6 months to return these to all the people that you stole them from, except for if somebody were to become known to you as being somebody that you stole them from. So if you confiscated these items from somebody and they come to you and say, hey, you stole this from me, I want my property back and I want it back now, then you have to return that ASAP. That also includes people like Rarebreed, for instance, who had a whole bunch of inventory confiscated. That is, return that immediately. Because this originally was supposed to be in effect, as in they needed to return all that stuff by literally tomorrow. So return that to them right now. There is one portion here that I actually think that Judge Reed O'Connor messed up. And you guys can let me know if I'm over target on this one. He had in there the argument about prohibited persons. I don't think that actually applies in this situation, because the court has said that these are not machine guns, and because they are not machine guns, they would revert to the classification of a trigger, which is a firearms component, which you do not have to have any kind of background check on. It is not a regulated item, as in it is not a serialized portion or anything like that. It is not classified as a firearm. It is a firearm component, just like any spring or anything like that. And those components can be used in black powder technology, which convicted felons and drug abusers are legally allowed to access. So to have that in there and not expressly address the fact that the ATF is trying to use this as a, hey, we don't have to return these things because we don't know who prohibited persons are, in my opinion, cedes a little bit of ground to the ATF on that. That, in my opinion, was a mistake, and he should have expressly addressed that portion of their argument. He did not do that in this case. But other than that, this is beautiful. It says, ATF, you done messed up. Get the stuff back to the people that you took it from, and you are wrong. Now, where does it go from here? I am assuming that the ATF has filed an appeal to the Fifth Circuit proper for a stay. I have no reason to believe that, having been up there already and pretty much agreed with what Reed O'Connor said the first time, that they would issue a stay. I don't see any indication that would be the case, but we will be watching this to determine if that ends up being the case. So all eyes right now on the Fifth Circuit Court of Appeals. Will they issue a stay and block Reed O'Connor's decree here? Anyway, that's all I got for you guys today. Thanks for tuning in. Sorry it was a little bit late this morning, and we'll see you in another video here at the VSO Gun Channel.